Hello, and welcome to another episode of the Legislative Lens Spotlighting State Laws podcast. In this episode, we're dealing with House Bill 900. We're going to be banning sexualized books in school systems. And this law, which was passed in the legislative session number 88 of the Texas legislature on the regular session, in pretty much by, I would say, summertime of this year, of 2023, it was passed and has gone through some litigation since then. So we're going to kind of go dive into it a little bit here and kind of go at the core of what it's all about. House Bill 900 is really kind of I'm not really sure what to go about this, but this is kind of a law that is banning sexualized books before they're sold to school districts, and it requires booksellers and vendors to assign ratings of said books with sexual content at the cost of the school or of the bookseller. And schools will also have to get parental consent before a child can access sexually relevant material in the library, but sexual explicit books cannot be sold in schools. Okay. Kind of how this started. It kind of started in Fort Worth, and the library closed down towards the end of the school year in 23 and went about pursuance of the law. It's pretty much a very vague on the language. It is vague in gray area throughout the entirety of the law in what is actually considered sexualized material. And this is probably and has been litigated ad nauseum here. So let's just kind of dive into this litigation a little bit. And this law is going to probably be repealed at its core. And so on August 31st, Texas Judge Alan Albright issued a temporary injunction against House Bill 900, known as the Reader Act. And really, it was a 52-page lengthy just if you read through the decision, it is a basically very actually, I'm sorry, it was 59 pages total. It was very unflattering towards the government in this situation that they're at its core, it's a message of free speech. And this is basically saying that there is no language in the statute that ensures that any decision made by the Department of Education in Texas with respect to the rating of a book will be any more accurate, allowing for enormous possibility, if not probability, that entirely arbitrary and conspicuous at best. In other words, vendors must decide between either accepting the state's administrative agency substituted speech as their own or being effectively blacklisted. There is no mechanism to appeal the TA ratings and with respect to any book, and there is no way to dispute to regain the ability to sell legal library material. The sum finds total that the bill does in fact violate the free speech clause in the First Amendment because the bill effectively compels the speech of the bookseller to assign only ratings that would be acceptable in the Texas Department of Education, regardless of the contextual analysis of the book or the community standards of the book. The bill requires to be considered when assigning the rating in the first place. It is a pretty big victory for free speech everywhere on that situation. But what is important for our members to know is that districts should not be making moves to rate books or remove books from libraries or classroom shelves under the banner of House Bill 900. Local book challenges itself is on the local school board level, and process will still exist. But we urge teachers, and that's what the bill writes and of the lawsuit writes here. So at its core, and what it's deciding upon is that the reason why this came about is that someone, some way, somehow, in a school district, found a copy of a book that was sexualized in manner, and they're trying to control that material be, allowed in school districts. However, the way this law is written is too ambiguous, and it needs to be shored up in the fogginess of the writing. So this particular podcast episode is going to talk about really at this level. It is not the fact of the First Amendment or the lack of the First Amendment. It is the fact of, can we please do better as adults to talk about these things openly and write legislation that actually is clear, concise of what the bill wants it to achieve, what the legislators want to achieve. Stop writing these laws in foggy gray areas. Okay. Spell it out there for everyone to understand, and everybody will be better for it. However, when you have laws like this that really at its core mean well, it is an abomination of true legal writings to try to pass a law and then get it passed in the legislative cycle and then get it overturned because of gray and stupid language. Okay. The U.S. Court of Appeals for the 5th District has set a tentative schedule as well to decide whether or not a judge's order blocking the state law should stand. But as administrators say last week by a separate motions panel of the Fifth Circuit panel enforced, meaning that despite being founded unconstitutional, the law now is in effect putting booksellers in a precarious position. All right. In this reply brief to of the 59 pages of the written opinion and order officially blocking the law from taking effect, the plaintiffs wrote in October 2nd reply brief that plaintiffs argue that the stay is causing irreparable harm into the plaintiffs and putting Texas booksellers in jeopardy. Furthermore, the plaintiffs argue allowing the injunction to take effect is the only way to maintain the status quo while the case is being litigated, since the new law imposes enormous, unprecedented, and according to district court, unconstitutional burdens on the plaintiff. So the 5th District Court of Appeals in the United States Supreme Court had it scheduled for December 13th as a deadline for amicus briefs by the 20th, and the state's reply brief would be due January 10th. Under that schedule, oral arguments will be not set until February at the earliest. So by next month, February, it's going to be really important that we all understand that at the core root of this law isn't about free speech. It's the fact that you don't want sexualized material going to kids. And I think that's universally accepted. It's the way the law is written that is travesty. And I think we need to do a better job as adults and litigators and legislative bodies and to do the right thing in order for our society as a whole. I mean, I don't understand what book might have taken this by storm, but let's talk about it. Is it really important for a kid to read about sexualized material when they're 6 or 7 years old? No. Now, if it's a high school book, let the local school board vote on it. Okay. And go about that. Get student consent, get parent consent to do so. That definitely means well. All right. So hopefully by February, we'll get some more clarity on the House Bill 900. But in the meantime, it's actually on the books now, and it's kind of putting a spotlight on it for sure about what can be read inside schools and what can be sold to schools. Now, the book can actually be placed in the library of schools and be rented out. It just cannot be sold at a widespread level to the school system. So that being said, everybody, quick episode. 88th bill, House legislator, House Bill 900. Really, really intriguing bill. But hopefully we're going to continue on season 1 of Texas, and hopefully you continue to join me. If you feel free to also continue to research your own self as well, feel free, but have fun. Have a great day.